and that's when like I got caught up in traffic, so I had to like
Had to go.
I had to go through after that.
Well, sometimes we're put in a position where we don't have any choice but
Yeah.
to, it's, I found myself in a similar predicament, in Canada a number of years ago. I could either punch it and go straight ahead or get T-boned by a bus.
Oh yeah, no.
I punched it and went right through that red light.
Well, glad you did.
But hey, Mr. On, I'm going to sign an order resetting the matter to October 10th. And once again, if you're paid up, no need to reappear, but if you haven't been able to, you need to come back. When I'm signing an order, if the computer will let me do that. To that effect, you know, this will get behind you one way or the other. But the important thing is you got you're on a good path. You're on a good path. Stay there. Stay there. Get a copy of today's order before you leave the building, at the window outside and to the left. And good luck to you. If I don't see you again, I want to wish you the best of luck and stay safe, stay well, stay sober, and just enjoy life.
Thank you, Your Honor.
Mr. Ron, thank you. You take care. Have a good one.
You as well.
Yeah, Donnie, that's, take a look at this here. Is there any way to rearrange? Is that we have more than one? Back on record for the no-shows for the 8:15. Docket number 1. Mr. Burkhardt has been reset. Docket number 2, Carissa Geller. At the end of an SOC, failed to appear.
Yeah,
So ordered. Next would be Tim Higgins, docket number 4.
15.
So ordered. And that leaves us with Melissa Ulrich, next page, docket number 6. Neither Mr. Valley nor her have appeared.
25.
Given the offense, I agree. So ordered. And Jenna White.
15.
And with that, we can go off record until we hear from the jail.
Green chair. Let's see, we're, oh, yeah, they haven't, brought us into the meeting yet because they're still, with some stuff in the courtroom. I tried to reach out to your.
On record, I'll defer to the parties for the order in which cases are called. Mr. Crowe, I assume you're here with, in connection with docket number 1, Robert Bailey. Morning, sir. Is that your full name, Robert Bailey?
Yes,
Okay.
Robert Michael Bailey.
Defer to the parties for the status of the matter.
Your Honor, I think we can use the resolution in this case. We will do it in 3 minutes. This one?
Any other conditions, law abiding behavior 250? And pulling up the document and need I guess Crowe will need your signature on the document. Mr. Bailey, I'm looking at the SOC stipulated order of continuance, which in reality is a contract between yourself and the city negotiated by Mr. Crowe on your behalf. Under the terms of the contract, if you comply with the conditions, which are simply stay out of trouble, 250 in costs, charges will be dismissed. In return for this agreement, you've given up your right to go to trial, have witnesses. If there's a violation of the of this agreement, new charge, failure to pay the costs, anything at all, city proves there was a violation, we'll come back, we'll have a hearing based on the police reports. And that would result in more likely than not than a conviction for one misdemeanor bearing up to 1 day short of a year in jail and another bearing up to 90 days in jail. You've got an agreement here where a couple of fairly serious charges can go away, but whether you're going to do that or not is up to one person, and that is you. We learn from our mistakes. We all make them, but if we don't learn from them, we are condemned to repeat them. Hopefully this has been something of a learning experience and something you can 30 days down the road or 3 months down the road put behind you. Any question at all?
No, Your Honor.
What I want you to do is with Mr. Crowe, go to the window outside the courtroom to the left. You'll be able to get a copy of the agreement. I want you to review it carefully. And of course, if you have any questions at all, give Mr. Crowe a call. Mr. Crowe, anything further? Yep, there's a signature spot on there for, well, I guess that we can't do that. We'll worry about that. We'll cross that bridge another day.
If we can print that.
That's wave signature. We're doing this in open court and copies. It'll be fine. Signing and closing. O courts is a little, I'm a computer dinosaur and O courts is sometimes a bit of a challenge for me. But Mr. Bailey, I'm going to wish you the best of luck. Take care of yourself. May not see you again. And if I don't, I'm going to wish you the best of luck. Take care of yourself.
Thank you.
Okay. Good luck to you. Mr. Crowe, take care. And I guess we can go to the jail. Ma'am, you're waiting for your attorney. I assume. I don't know. Oh, okay. We have some business to take care of with the jail. We'll do that now. And then we'll get to your matter. Here, go ahead. Use the jail.
Yeah, thanks.
We're going to go to the in custody calendar. Mr. Haverco, good morning. Can you hear me?
Morning, Judge. This is, let me just turn to the 8:30 calendar here. This is Stefan Norton. He's got, let's see. He's got the pretrial hearing that
Look, I
he,
did not catch the name. Could you
oh,
repeat?
pardon, Your Honor?
Pardon?
Oh, can you hear me, Judge?
Now I can. You're a little bit garbled, but
Okay, I'm sorry about that. I'll raise my voice a little bit in an attempt to have you hear me. We're in this small meeting room, and the equipment over here never seems to be really great. So this is Stefan Norton. He has a pretrial hearing where he represented himself. I looked in the docket. He at one point he thought he was gonna try to hire somebody on that case and didn't wind up doing that. So case got designated as pro se. He'd like me appointed on that case, and then he also, I think he's requesting counsel. And so as part of that, we would want to proceed with his arraignment on the DUI and interlock charge.
good morning, sir. Is your full name Stephen Mark Norton?
Yes, sir.
Mr. Norton, you're here for a couple of things. One, a pretrial. You were representing yourself on that. Apparently, you were going to hire an attorney, but evidently have not done so as well. You're also here for an arraignment on 2 new charges. It's alleged by way of citation that on or about July 25th, 2024, you committed the gross misdemeanors of driving while under the influence of intoxicants and also operating a vehicle without ignition interlock when required. Each of those is a gross misdemeanor. The maximum penalty on conviction would be 364 days in custody and or a $5,000 fine. I'll appoint Mr. Haverco to enter pleas on your behalf with regard to these charges. Mr. Haverco?
Thank you, Your Honor. Would stipulate to probable causes to both charges. Would ask the court to enter not guilty pleas as to both.
Plea of not guilty be entered. We'll set the matter for a pretrial along with the earlier charge.
And I assume, is the court appointing me on the earlier charge?
Pardon?
I assume the court's appointing me on the earlier charge as well?
For purposes.
Yeah. I would just suggest setting it over 2 weeks. We're not going to address conditions of release at this time. I've discussed the matter with Mr. Norton in consideration of his record and the bail as originally set. So we may request to address it later, but at this time, we're not going to address it.
I'm going to leave the conditions as currently set. They will remain in effect. I will readdress at the request of yourself and Mr. Norton at any time.
Thank you, Your Honor.
Pretrial.
So it'll be reset 2 weeks.
Thank you, Your Honor.
Needless to say, the actions will be calendared. Ready to proceed.
Thank you, Judge. This is Leighton Lettle.
Mr. Lettle, good morning again.
Good morning. Matter comes on for a pretrial hearing on a controlled substance charge. I placed a jury trial waiver form in Oak Courts. I don't have a way of having him sign it from here, unfortunately, but I've discussed that with him, and that is what he wishes to do. And so we just want to set a trial confirmation date and a bench trial date at the noon hour where the court can find some free space.
Any idea? Conducting a trial is going to be impossible by way of Zoom. Mr. Lettle, do you know when he's going to be available to appear in person?
When do you get released?
October 16th.
He gets released October 16th. What I guess, thanks for bringing that issue up, Your Honor. I guess I assumed that, Your Honor could, because he does need to be there in person, and I assumed he would. But perhaps Your Honor would be willing to sign essentially a transport order just for that day? Just to have Yelm Police bring him to court, or?
We certainly can, unless the city have any input. I have no problem with that.
Okay.
That is being prepared as we speak.
Thank
Mr.
you.
Little, I'm going to wish you the best of luck. Once again, you're not being held on our case. You're simply there in connection with another jurisdiction, Lakewood, I believe.
Correct.
You want to set a date for a bench trial at this time?
Yeah, let's go ahead and just set one, and you know, whatever date we pick, just set a trial confirmation date 2 weeks prior.
Let's set a readiness hearing for August 29th.
Okay,
And how about the bench trial September 12th?
sounds good.
Not going to work. That we shall. The order's being prepared at this time. Mr. Little, I'm going to wish you the best of luck. I want to make sure you have Mr. Haverco's contact information so you can stay in touch with him, okay?
Okay,
Thank you, Judge.
thank you.
He had your phone number. This is what happens. I have to go to the very edge. Even then, sometimes it opens up. Very, very careful.
Pepsi on Ranger. Hey, Judge.
Good morning again, Mr. Everco.
Good morning to you, sir. This is Charles Panis.
Good morning, sir.
Item number 9 on the 8:30 calendar.
Good morning, sir. Is your full name Charles Agua Panis?
I am, sir.
Hey, thank you. I'm appointing Mr. Everco to represent you in this matter. Mr. Everco,
Thank you, Your Honor. I had an opportunity to discuss with Mr. Panis, what an arraignment is, and generally people plead not guilty and set dates and that kind of a thing. And but based on the city's proposed resolution, we'd like to take care of the matter today. I placed in O Courts a 6-month stipulated order of continuance. He's indigent. The city's not asking for any fine. And so all he has to do is just basically not commit any criminal law violations for 6 months, at the end of which time the city would move to dismiss the matter. And he understands, as far as the arraignment goes, he understands he has the right to have the charge read to him in open court and the elements that the city would need to be proved and the maximums that can be imposed, and he understands his rights. And again, I did take the time to review his rights with him, the rights pursuant to an arraignment, and I did have an opportunity to review the police reports with him as well.
Panis, do you disagree with anything at all Mr. Everco just said?
I do not, actually, it's very good. Thank you.
Yep, he's got an agreement for you. 6 months down the road, we're simply going to dismiss the charge, close the case, if you just simply stay out of trouble, okay? That's
Okay.
the only condition.
That works for me, sir. Thank you.
Now, if you violate the order, if you get a new charge, you come back, you've given up your right to go to trial, we'll have a hearing based on the police reports. And if I do find you guilty, which is more likely than not, I could sentence you up to 180 days in jail. Don't want to go there. You can get this charge dismissed, so I need you to take advantage of the agreement, okay?
That sounds good, sir.
Mr. Everco, any questions?
Oh, no questions, Your Honor. Thank you, Judge. I don't have anything to add. Thank you.
We'll send the jail a copy of the agreement for Mr. Panis for his review.
Okay, thanks, sir.
Panis, good luck to you. You take care of yourself.
Good day, Your Honor.
Ready to sign?
Yeah.
Wait. Oh. Go back. Leave site. Okay. That. Now we're okay.
Your Honor, I just want to report back to the court. We're still waiting for Mr. Lance Houston. Apparently, they were having some problems with him this morning, and now where things are at is they're in the middle of a head count, what they call a head count in the jail. So I just asked the jailer here, how much longer would it be before they bring him over? And he said, unfortunately, it's going to be another 30 minutes. So I thought I'd tell Your Honor and leave it up to you as to if you want me to be here or if you want to reset it, or I'm not sure.
Unless Mr. Redfield has a question, I'm inclined to reset it to August 15th and allow you to come to court.
Okay, so we'll just I'll note on my calendar. We're just resetting it 2 weeks, and so I will now proceed to the courthouse. Thank you, Your Honor.
Okay, Mr. Abigail, we'll see you in a few minutes.
Okay.
Thereabouts. You take care of yourself. Drive careful.
Okay, thanks, sir.
Good morning, Mr. Goodman. It looks like you're muted. Go ahead and unmute yourself. We'll address your matter at this time.
Thank you. Good morning, Your Honor. And here for the Amanda Biles matter. Ms. Biles is present in the courtroom, Your Honor.
Ms. Biles is in the courtroom. Ma'am, let me confirm for the record, your name is Amanda Lynn Biles.
Yes, Your Honor.
Your attorney's present by way of Zoom. I'll turn to him for the status of the matter.
Thank you, Your Honor. And for the record, Jeremy Goodman on behalf of Ms. Biles, who we just confirmed is present. This is our first pretrial. Is a defense motion to continue. Need some more time to investigate as well as negotiate the matter. Prior to going on the record, I did call Ms. Biles and discuss her right to a speedy trial. I did execute that on her behalf in O courts, but we did have a chance to review that together, and she's in agreement about that speedy trial waiver. I'm asking to set the matter over to August 29th at August 29th at 11 a.m., if that's still available. And yep, we'd ask to reset to that date.
Mr. Goodman, it'll have to be 9 a.m.
Okay, now let me double check my calendar, Your Honor. I might have misread that court's calendar. Something my bad. I just want to make sure I'm available for that one. Just a moment.
Well, let's just leave it as is and note it for 9.
Yeah, I can make that work, Your Honor. I do have one question for the court. Depending on the status, should the matter be at the point of a resolution, could that be done on that same date, Your Honor?
City has no objection.
Perfect. And then the final question would be, if this case does need a second continuance at that time, does the court have any issue with the 3.4 appearance so Ms. Biles can avoid missing work? Should we be in a similar posture at that point?
Defer to the city. City has no objection.
Perfect. Thank you, Your Honor. So we asked for that 8/29 at 9 a.m. Thank you so much.
Mr. Goodman, thank you. You take care. Matter is reset to August 29th at 9 a.m.
Thank you. And Amanda, I'll give you a call in just a minute. As my last matter, Your Honor. Have a good rest of your day.
You take care. Have a good day. Ms. Biles, I want you to go to the window and get a copy of today's order. Stay in touch with your attorney. The order will say 11 a.m., I believe, but it's going to be changed to 9 a.m.
Okay.
Thank you for appearing. Free to leave. Go to the window first, and we'll see you back here maybe on the 29th. Take care of yourself. And you're here. Good morning, Mr. Crone. You're muted. If you unmute yourself, we can address your matter at this time. I take it you're here in connection with docket number 2, Chris Bertrand.
That's correct. Good morning, Your Honor.
I'm looking in the O courts. I see a motion to reset the matter to September 12th. I'll hear from you, Mr. Crone.
Of course, for the record, Attorney Jay Crone here on behalf of Mr. Bertrand. I do have express authority to appear on his behalf today under Rule 3.4. I also discussed with the city appearing on his behalf via 3.4 today to continue this out to September 12th for further investigation and negotiation. We explicitly had a conversation yesterday about waiving speedy trial as well. He did authorize me to sign that document on his behalf.
Hearing no objection from the city, at the request of council, we're sending the matter over to September 12th. I'll sign an order to that effect. We'll send you and your client a copy of today's order. Mr. Crone, thank you for your patience. You take care. We'll talk to you again.
And I actually do have one more matter, Your Honor, number 4 on the docket as well, Aiden and Conlon.
Aha, okay.
And then once again, for the record, Attorney Jay Cronier on behalf of Mr. Conlon, once again under express authority via Rule 3.4 to also set this over to September 12th for further investigation and negotiation. Been in great contact with Mr. Conlon. We had conversations yesterday about appearing on his behalf and waiving speedy trial. Thank you.
No objection from the city, I assume? So ordered. So ordered. Again, we'll be sending you and your client a copy of today's order. Mr. Crone,
Great. Thank you so much.
take care of yourself, and we'll talk to you in September.
Perfect. Have a great day.
Take care. Hold on, hold on. Don't do anything until I catch up. Morning, Mr. Liu. Call the matter of Yelm versus Jonathan Liu. Mr. Liu, good morning.
Morning, Your Honor.
I assume your attorney's probably on Zoom as well.
Yes, Your Honor.
Mr. Gargo, that's Mr. Liu is here as by way of Zoom as well. Call the matter at this time.
Yes, Your Honor. Sorry about that, Your Honor. And for the record, Tony Gargel on behalf of Mr. Liu, who's present on the Zoom. Your Honor, first and foremost, we do appreciate you allowing Mr. Liu to appear remotely, given that he's no longer in the military, no longer resides in Washington. But we are ready to resolve this case today. We have come to an agreement with the city where Mr. Liu will be entering into a 1-year stipulated order of continuance in this matter. We have gone over that document line by line, answered any questions that he may have. We went over the important constitutional rights that he's giving up by entering into this agreement. We talked about the charge of a DUI and the ultimate resolution if he lives up to his end of the bargain, which would be a dismissal. Your Honor talked about the conditions. He understands what he's doing today. Like I said, we have gone over this line by line, and we would be he is prepared to enter into this knowingly, voluntarily, intelligently, Your Honor. Thank you.
Thank you, sir. Mr. Liu, do you disagree with anything your attorney just said?
I do not, Your Honor.
Your attorney's worked out a contract, an agreement with the city on your behalf, under the terms of which a year from now, the charge, a very serious gross misdemeanor, can be dismissed if you comply with conditions that are set forth in the agreement. The most important one of those to me is that you do not reoffend. No criminal law violations, especially when it comes to consumption of any substance. Likewise, you're to, according to the agreement, obtain a drug and alcohol evaluation within the next 30 days or as soon as you possibly can, and comply with any recommended treatment. Now, in return for the agreement, you've given up your right to go to trial, have witnesses appeal if things go wrong at trial. If there's a violation of the agreement and the city proves that, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction for a very serious offense. I've said many times, and I still believe that a conviction for DUI is more serious in terms of effect upon your life than quite a few felony charges. I'm going to wish you the best of luck. Your attorney has put you in a position where you can walk away from this a year from now with no significant damage, but you must comply with the agreement, and that includes $250 cost. Mr. Liu, any questions?
I have no questions, Your Honor.
I will be sending, rather, my staff will be sending a copy of the agreement to yourself and your attorney. If you have any questions at all about anything that's in the agreement, give your attorney a call, okay?
Yes, Your Honor.
I'm going to wish you the best of luck. We either learn from our mistakes or we're condemned to repeat them. I hope this has been an experience that you'll learn from. Anything further from your attorney?
Nothing further, Your Honor. I will be following up with the court. We do need to update the address, but I'll send over an email, and just so the court knows that the evaluation ADIS have gotten acknowledgement that those have been filed with the court.
Perfect. I realize 30 days is a little bit short. There'll be a lot of forgiveness there.
Yeah.
No problem. You take care. Have a great day. And Mr. Liu, I'm going to wish you the best of luck. You take care of yourself. You've got a great agreement here, but it's up to you to follow through and take care of it. Okay?
Yes, Your Honor. Thank you.
Thank you, sir. Take care.
Thank you, Your Honor. Thank you, counsel.
If I move that, I can move the select. We're on record. They're calling the pretrial calendars. Mr. Averco, I'm going to defer to you and,
Yeah, thank you. Let's see.
Mr. Hatfield for the order and which the cases are called.
Let's see, the first case I think is going to be on the 10 o'clock calendar, Mr. Hoffaker. Yeah. come on
Jonah
up.
Hoffaker?
Yeah.
Morning, sir. For the record, full name Jonah David Hoffaker.
Correct.
Good morning. I'll turn to Mr. Haverco for the status of the matter.
Thank you, Judge. Matter comes on before the court for a pretrial hearing for minor in possession, consumption of alcohol. Parties have reached an agreement, that being a stipulated or continuance. I've reviewed that with him. It's in all courts and it is for a period of 6 months, $250 probation fee, at the end of which time, if he complies, the city would then move to dismiss.
Mr. Hoffaker, do you disagree with anything Mr. Haverco just said? No. I'm looking at the SOC in the old court system here. It's a contract. Your attorney has negotiated with the city under the terms of which 6 months from now, this case will be dismissed if you have no further law violations, and that would include not consuming anything that you're not of age to consume. $250 in costs, general law-abiding behavior. We can review the file in 6 months and dismiss the charges if you've been in full compliance. If the city proves you have violated the agreement, we'll have a hearing based on the police reports, and that would result in a conviction, more likely than not. Any questions about anything I've just said? No. I'm signing off on the agreement as we speak. If old courts will let me do that, I'm going to have to do it. Mr. Hoffaker, what I want you to do is go to the window outside the courtroom to your left. They'll be able to give you a copy of today's agreement. What I want you to do is look that over carefully. And if you have any questions about what it means, give Mr. Haverco a call, okay? I'm going to wish you the best of luck. You take it easy and stay out of trouble. Good luck to you. Good luck.
Your Honor, the next matter is Mr. Miles Johnson. It's item number 8 on the 10 o'clock calendar. Matter comes before the court. 1 count of assault 4th degree, 1 count of harassment. It's going to enter a plea by way of an Alfred plea and also the in re bar doctrine to disorderly conduct.
Good morning, sir. Is your full name David DeAndre Miles Johnson? Yeah. Do you disagree with anything that Mr. Haverco just said? I'm looking at a statement of defendant on plea of guilty to 1 count of assault in the 4th degree, which is being dismissed, and also a 1 count of disorderly conduct amended down from a harassment charge. Disorderly conduct is a misdemeanor. The maximum penalty on conviction to be 90 days in jail and or a $1,000 fine, which I'd be free to impose if I accept the plea. If I do accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to the maximum. With that in mind, with regard to 1 count of disorderly conduct agreed upon, contended that you committed that on May 10th, 2024. How do you plead guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you to make a plea guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 indicates that this is an Alfred plea That means basically that you've gone over the case with your attorney, reviewed the discovery, and want to enter the plea that you're entering to take advantage of the plea bargain, realizing that if the case were to go to trial, things might not go well. You realize that. I will find that the case does satisfy the factual elements of the offense. Recommended sentence, Mr. Haverco, is
Just suspended time, let me just all suspended time, $250 costs, and just suspended for 12 months, at the end of which time, case could be closed.
Mr. Miles Johnson, you have a right to tell me anything you wish. You don't have to say anything, but if you have anything you want me to know, now's the time. You're free to come in and watch the proceedings anytime you want, but yeah, I'm hoping you'd rather sit in the audience rather than be where you are now. I'm hoping as well. We learn from our mistakes, or we're condemned to repeat them. Following the recommendation, 90 days in jail, suspended on the condition of simply law-abiding behavior, and pay a $250 fine. The fine is the least important part of this to me. If you have any issues making the fine payments, give us a call. Come on in and we'll figure out how to deal with it. Oh, yep. Payment plan will be set forth in the agreement, and it's usually $25 a month. That's a problem, let us know. Signing the electronically, signing the documents as we speak. Mr. Miles Johnson, what I want you to do is get a copy of today's paperwork at the counter. Look it over carefully. Any questions at all, give your attorney a call. Good luck to you, sir. Take care.
Take care.
Morning, sir.
So this is Colton Munkers. It's item numbers 9 and 10 on the 10 o'clock calendar. Parties have reached an agreement, that being on both cases. Stipulated order of continuance, 6 months, a $250 probation fee on both cases total. So in other words, 125 each.
125.
Yeah, 125 each. Payable over 6 months, conditions, just don't commit new criminal law violations, pay the $250. At the end of which time, then the city would agree to dismiss.
Mr. Bunkers, do you disagree with anything at all Mr. Haverco just said? He's worked out a contract between you and the city under the terms of which, if you stay out of trouble, 6 months from now, we can simply dismiss both charges and close the case. The first charge, minor possession, not necessarily the minor, but what can happen when you, and happen to others and to yourself when you are in possession of consumption. Not a good thing. Now, in return for this agreement, you've given up your right to go to trial. If you violate the agreement and the city proves that, we can have a hearing, and that hearing will be based on the police reports, nothing more, nothing less, and would result more likely than not than convictions for two fairly serious charges, one of which would result in the suspension of your license for a period of time. You don't want to go there. You have a chance to get this off your record. I'm going to wish you the best of luck. Mr. Munkers, hopefully you will learn from the situation. Any question at all? And once again, I want you to get a copy of the instrument at the counter outside the courtroom to your left. Review it carefully. Give Mr. Haverco a call if you have any questions. Good luck to you. Take care.
Next matter is going to be Mr. Ortiz Mendoza.
Okay.
So this is Mr. Ortiz Mendoza. It's item number 11 on the 10 o'clock calendar. As of yesterday, a couple days before, he is currently licensed. So I think the city has a motion.
Wonderful.
So we assume that we would be making an admission to amend it to no valid operator's license with ID, $150 cost.
Mr. Ortiz Mendoza, that's, do you admit that when you were cited on June 1st, you didn't have a valid license on your person? I'm going to assess a $150 fine. Now, a conviction for DDoS second, that'd resuspend your license for a period of a year. You don't want to go there. You have your license back. You want to keep that license, huh? We live in a world you pretty much have to be able to drive. I will sign the infraction disposition. The important thing to me is you drive in such a way as your license doesn't get resuspended. If you have any problem making the fine payments on this, let Mr. Haverco know and we can certainly readdress the matter and deal with it, okay? I'm going to wish you the best of luck, Mr. Ortiz Mendoza. You take care of yourself, all right?
Yeah, so just before you go, look through the window. Yes, I know. Next matter is going to be Timothy Riddall.
I know, sir, but for the record, I need to confirm your full name is Timothy Lee Riddall. Good morning, Tim.
Matter comes on for a pretrial hearing, controlled substance, knowingly unlawfully possessing a controlled substance. Matter comes on for a pretrial for that. Yeah, I've had an opportunity to review the police report with Mr. Riddall and also discussed with him that one of the options on the case was to set it for trial by jury or before a judge on the theory that right now the Washington State Patrol Crime Lab is, from what I understand, quite a bit behind in analyzing controlled substances, and that might be a way to push the matter where the city might not be able to therefore prove it and, you know, explain to him why that could be an option. That said, he's quite interested in not coming back to court. And so it's his choice, where he would like to enter a plea. He's doing it by way of an Alford plea. I've explained to him what an Alford plea is, which is he doesn't necessarily agree with the evidence itself, but does agree that the evidence that he understands that's available to the city were presented to a fact finder by way of a jury or judge, and were any evidence presented that he has, that it's highly likely that a guilty finding would be rendered. And because of that, he doesn't wish to contest the evidence, and he also wishes to take advantage of the city's plea offer, which is all suspended jail time. And because he is indigent at this time, the city would not be asking for a fine or any kind of probation fee, no financial costs.
Mr. Riddall, do you disagree with anything at all Mr. Haverco just said? I'm looking at a statement of defendant on plea of guilty to one count of possession of a controlled substance, knowing possession. That's a gross misdemeanor. The maximum penalty on conviction be 180 days in jail and or a $1,000 fine first offense. I'd be free to impose that regardless of what's recommended, realizing that less is recommended. Should I see fit to do so? If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. And as I indicated, that would be, could be up to the max. With that in mind, as to one count of knowing possession of a controlled substance within the city of Yelm on November 13th, 2023, how do you plead guilty or not guilty? To make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made, and I accept that this is what they call an Alford plea. In other words, you've gone over the case with your attorney, considered the pros and cons, and decided to take advantage of the plea bargain instead of having this hang over your head for the next month. I will find that the record does support the factual elements of the offense, and I will accept a plea of guilty. Recommended sentence is simply suspended jail time and a fine. Tim, anything you'd like to tell me?
No.
I'm going to accept the recommendation, of course, 90-90, all suspended on the condition of law-abiding behavior and a $250 fine. We've seen each other a number of times over the years, and it's good to see you. And I want to see you save your life. I read a lot about the statistics with regard to controlled substances as they relate to fatalities, and it's still startling every time I go over that. How many thousands of people we kill? It's basically people that kill themselves by accident due to controlled substances. I'm going to wish you the best of luck, Tim. You take care of yourself. I'm signing a judgment and sentence reflecting the sentence. And what I want you to do is get a copy of that at the window. Look it over carefully. Give Mr. Everco a call. And I want to thank you for appearing. Good to see you. Take care.
Thank you, Your Honor. Nicholas? Next matter is going to be,
Mr. Smith?
there we go. Yeah. This is Nicholas Smith, item number 14 on the 10 o'clock calendar. Comes before the court for a pretrial hearing on a supplying liquor to minor charge. And parties have reached an agreement that being a 6-month stipulated order of continuance on the condition that you have no criminal law violations, that pay a $250 excuse me, probation fee. I don't know if he's going to pay it today, but I'd ask for a time payment agreement, at the end of which time then the city, as part of the agreement, would move to dismiss.
Smith, again, for the record, Nicholas D. Smith is your full true and correct name. Disagree with anything Mr. Evergo just said? I'm looking at a SOC, stipulated order of continuance, which in reality is a contract between yourself and the prosecutor, negotiated by your attorney, under the terms of which this charge can be dismissed, it can go away. But there's conditions here. You need to stay out of trouble. Law-abiding behavior, and I believe there's a $250 cost associated with it. In return for the agreement, you've given up your rights to go to trial. If there's a violation, the city proves that. We'll have a hearing based on the police reports, and you know what that would result in. The problem with this charge is, and I've seen this a few times, is you never know once the cat is out of the bag where it's going to go. That's a neighbor, in fact, one of his sons had a party. There was some driving afterwards. There was 3 fatalities that resulted from that driving. I think he eventually wound up, well, besides having to bury his son, go through bankruptcy because of the lawsuits. You know, you never know where something like this is going to go or what the results are going to be. You may think you're doing the right thing and the right time, but sometimes things go really bad. I'm going to wish you the best of luck. Once again, get a copy of the agreement at the window and look it over carefully. Any questions at all, give your attorney a call. I'm going to wish you the best of luck, Mr. Smith. You take care of yourself. Any questions?
Take care. Yeah.
Take care.
Next 2 matters are going to be for Caden Long. Why don't you come on
Ms.
up,
Long,
Ms.
good morning. Thank you for appearing.
Here. Ms. Long has signed, and I have placed in Oak Courts a jury trial waiver. And asking to set, that both matters be, they're different matters, but just for efficiency, would ask that both matters be joined.
If there's an agreement to.
Yeah, I don't think the
for
city would
joinder.
have an objection. Yeah, and just has to be joined, and then let's find a noon hour, trial date for Your Honor, and, set a confirmation date.
Okay, Ms. Long, what we do is this, going to trial is kind of a serious step, in the matter. For that reason, we have a trial confirmation date. We're gonna give you 2 court dates. One, to make sure everybody's has the information they need, they're prepared to go to trial. Sometimes there's motions, for further discovery, suppression of evidence, that sort of thing. But these 2 court dates, you need to appear for them both. And, first is to confirm, for trial, and the second one is to actually go to trial. Any questions at all? Any preferences to dates? Any preferences to dates? Timing?
No. What is the 23rd? 23rd is not a court date. Yeah, no, yeah. Yeah, you pick, Your Honor.
I'll defer. We'll have a readiness hearing and then we'll have a trial
Right.
date. We're preparing that as we speak.
Okay.
Ms. Long, any questions? Any conditions of release earlier set remain in effect until changed? Once
So
again, I want to
before you-
thank you for appearing. kindly.
Before you go, I think you gotta sign something. Trying to get it to click here. Okay, yeah, it's not loading. I'm clicking the pretrial conference document. It's just sort of.
Sometimes the courts is just a little slower than I am.
Should I close the browser and relog it? Oh, okay. Oh, okay. Let me try that. Yep, that worked. Let's see. Okay. Just trying to. Oh, there we go. I'm just gonna.
Long the 2 dates are, and you'll have this in writing, September 12th to confirm the trial date, and trial will actually be held on September 26th. Don't have to remember that, it'll be in the order. So, and again, when it's ready, after it's all signed off on, I want you to get a copy of that at the window and stay in touch with Mr. Everett. That's important.
Yeah, but just before you go, she can print up. Yeah, but she'll print up the order that shows the dates, so you don't forget. Yeah.
Ms. Long, thank you. You take care.
I still need to talk to to Ms. Robinson Treptow, but I need to maybe also just figure out who else is here. Oh, why don't you come on? So you're, which, Don? Yeah, it's up to the court, Your Honor, but, so This is Ms. Jody Dawes, D-A-W-S. She's on the 1 o'clock calendar for Raymond. It's a suspended driving third-degree case. She mentioned to me she just got a job and she has to report to work this afternoon, and she'd have to miss work at her new job. And so I told her that I'd ask the court if you'd accommodate.
Spelling of the last name?
D-A-W-E-S, yeah, Dawes. It's number.
Oh, okay, got it.
Yeah, yeah. So item number 9 on the 1 o'clock.
Mr. Redfield, motion. Ms. Dawes, well, for the record, full name Jody Dawes. You were cited with a criminal offense, driving license suspended or revoked in the 3rd degree. The city's amended that to a civil infraction. If you admit that you didn't have a valid license on your person when you were cited, I will impose a $150 fine, and that will conclude the matter. Since there's no possibility of any jail time, you're not entitled to any attorney. Okay. Ms. Dawes, do you know what you need to do to reinstate your license? Okay, wonderful. No, this case isn't holding up your license at all. But as long as, take care of Sheldon, and as long as you're making the payments on the $150 fine here, you'll be okay. If you have any problem making the payments, I want you to let us know that so we can deal with that. Good. Ms. Dawes, thank you for appearing. You don't have to come back this afternoon. You're free to leave. Get a copy of the order at the window, and good luck getting reinstated. Take care. Oh, hey, you can't pass that up. Thank you for appearing.
No, but if you want to get the paperwork to show what happened, talk to the clerk and she can bring that up for you.
Thank you, Ms. Dawes.
This is the stipulated order of continuance agreement. First amended to first. Okay. So this, on the 11 o'clock, this is Mr. Robert Larson. It's item number 9. Comes on for a pretrial hearing for assault 4th degree, non-domestic violence. Parties have reached an agreement by way of a stipulated order of continuance. It's in Oak Courts. Charged first to be amended to disorderly conduct. Then the stipulation to be for 6 months, no new criminal law violations, pay a $250 court fee, probation fee. And at the end, which time in the 6 months, city will move to dismiss.
Morning, sir. Full name Robert, middle initial S, Larson. Yes. Do you disagree with anything at all Mr. Haverco just said? No. I am looking in Oak Courts at a SOC stipulated order of continuance. In reality, it's a contract between yourself and the city negotiated by your attorney, under the terms of which an already reduced charge of disorderly conduct can be dismissed, can go off your record. In return for the agreement, you've given up your rights to go to trial. If you violate the agreement in any respect, and the city proves that, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction to a fairly serious offense. Now, the conditions are fairly simple, and that is, number 1, stay out of trouble. No violations of criminal law. $250 costs payable at $25 a month, first payment due September 1. Mr. Larson, any questions? No. Again, we learn from our mishaps in life, or we're bound to repeat them at some point along the line. I want you to get a copy of today's agreement at the window at your leisure. Look it over carefully, and if you have any questions at all about what it means, give Mr. Haverco a call, okay? You take care of yourself. Any questions? Good luck.
See you. Next matter is going to be Last name Stevens, first name Abbott, item number 19 on the 11 o'clock calendar.
I'm catching up on.
You
Mr.
bet.
Stevens, good morning.
And so, you know, he comes before the court for a pretrial hearing on a suspended driving second-degree charge. I checked his driving status as within the last 2 days. His suspended status is now that of third degree. So based on that, I assume the city is going to make a motion to amend to no valid operator's license with ID, $150 cost to which we would admit.
I'll defer to the city. For the record, sir, name Abbott Harvey Stevens. Docket number 19. Stevens, do you admit that you didn't have a valid license when you were cited on June 9th? Come down to an infraction, I'll assess a $150 fine, but you were looking at the deed of a second degree, that's a gross misdemeanor. That's up to 364 days in jail. But maybe more importantly to you, that wouldn't happen, up to a year license suspension. It's, you don't want to go there. We live in a world where you pretty much have to be able to drive. I'll assess on your, based on your admission, I'll assess a $150 fine. Mr. Stevens, do you know what you need to do to reinstate your license fully? I would make that my advice to you is to make that a priority in life. Did have this figured out once. There. Mr. Stevens, I've now signed the today's order. Get a copy of it at the window outside the courtroom to your left. And again, if you have any issue at all making the fine payments, let us know. We can certainly deal with that. That's the least important. Just don't get cited again. Good luck.
Thank you.
Thank you, sir. Good morning, ma'am. For the record, is your name Colleen Marie Overah? If I mispronounce their name again, I apologize.
Sign here. That's just the waiver.
Ms. Overah, you're here in connection with a couple of matters. Let's address the new case. You were cited on July 29th, 2024 for the offense of DUI, driving while under the influence of intoxicants. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you on the new charge, and he'll enter a plea to that new charge.
Yes, would stipulate to probable cause, Your Honor, and ask the court to enter a not guilty plea. She has another matter that's on before Your Honor
For
today.
pretrial at this time.
That is the negligent driving first degree charge that was set today for a pretrial hearing. On anticipation that I would be appointed on the new charge, I have submitted into O Courts a motion for a continuance, which includes a waiver, speedy trial waiver, for the purpose of trying to figure out, you know, the next steps, maybe evaluation, you know, just essentially plea negotiations and, kind of figure out where to go from here. So we just asked to reset both to another.
About how
pre-trial.
far would you like to go?
I'd ask for 6 weeks because there may wind up needing to be, some sort of assessment perhaps.
September 12th,
Sure.
26th,
Sure.
September 12th. Zora, any conditions of release earlier set? I did, when you were released from custody, order that it's all ignition interlock and file proof. That you have until the 6th to do that. And all the other conditions remain in effect. Don't drive unless licensed and insured, and by all means, don't drink and drive at all. In fact, I think it'd be a good idea to make another condition is don't drink at all. That sometimes bad occurrences in our life turn out to be for the best good things. I'll leave it at that. The good news is yes, you are in some legal issue here, but you're here, you're healthy. You haven't hurt anybody, and I see that. Under it, nobody, you're okay. So we're gonna leave it at that. Resetting the matter to September 12th. I want to make sure that Mr. Haverco has your contact information. That's exchanged. Stay in touch.
So before you leave, go see the clerk and she'll print up the order from today that will have the dates. Okay? And then we'll talk. Okay. I'll give you that. You're welcome.
Again, get a copy of today's order at the window. Ma'am, thank you and good luck to you.
Next matter is going to be William Deacon, last name with a D.
Morning, sir. Full name William James Deacon. We'll address your matter at this time.
Check one thing real quick. We're ready to proceed, Your Honor. We've inserted into O courts a proposed stipulated order of continuance for 6 months, no criminal law violations. City's not going to ask for costs on this because he is indigent. They're not asking for any, treatment, but can I discuss the fact that that's just it's really a bad thing to be doing for his health. Are you? You are, okay. So this, I've just been informed, he's apparently has engaged himself into some outpatient treatment. So, so I think that's one of the reasons, indigency, and now combined with the fact that he's doing outpatient treatment, would rather the court not impose, costs. So there's more funds to help with other issues.
Mr. Deacon, I'm looking at an SOC, an agreement under the terms of which this case can be dismissed if you just simply stay out of trouble. No huffing, no controlled substances, that, save your life, okay? That's, and save your mind and your body. That's, now, your agreement here, allows for the case to be dismissed in 6 months if you fully comply. However, if you violate the agreement, the city proves that, you've given up your right to go to trial, and we'll have a hearing based on the police reports, and you know what that would go. That could subject you to some jail time. Don't want to go there. Mr. Abaco indicated that you are doing some outpatient treatment. I want you to stick with that. Some of these things we can't do by ourselves. We need help. If it sounds like you've made the choice to do that, I'm not going to order that. If you don't bring anything to treatment, it isn't going to do you any good if it's ordered. This has to be something you want to do. I want you to save your own life. Please get a copy of the agreement at the window outside the courtroom to your left. Look it over carefully and give Mr. Averco a call if you have any questions. Any questions of me? Good luck to you, sir. Take care.
Mr. Ray Bauman's here. I don't know if he's really on the calendar anywhere, but I don't know if, oh, is he? Okay.
He is.
Perhaps we
He
could take-
actually is an add-on.
Okay,
Mr. Ray Bauman,
all right.
come on up and have a seat. It's good to see you. You can find him on page 9 at the very bottom. He's added on as number 16.
Oh, okay.
Set for a pretrial today.
Okay.
And for the record, you're Sean Ray Bauman. That's it. He's an add-on. It's penciled in.
New date, I'll confirm. Do you have a phone number or anything? I don't think so.
Mr. Ray Bauman, what I want you to do is stay out of jail, and you can make big step towards that goal by just showing up. You know what they say? Showing up is half of it, if not 3/4. Hey, law-abiding behavior, stay out of trouble, but also show up.
That's it.
We're going to reset the matter. Not prepared to address it today.
Does he need to sign for that? Oh, okay.
What we'll need you to do, you get a notice that'll have the court date on it, and you can get that at the window out in front and to the left, okay? Mr. Ray Bauman, I want to thank you for showing up, and I can't emphasize strongly enough how important it is to just show up. I don't like to issue warrants for your arrest, and then I don't like to have you sitting in jail until I get the info and call. So, yeah, just show up. Yeah, I think it sounds like you're in fairly regular contract with the PD. So, yeah, and I think they're pretty good. They have, I understand, advise you that when you need to be here. With their help, yeah. If you don't have a phone, that just makes it tougher. But yeah, stay in touch with PD, and they'll direct you to like happened today. Thank you for appearing.
I have 3 people to talk to you.
Okay, we'll be Back on record, Mr. Africo?
So this is Ms. Robinson Treptow, item number 13 on the 10 o'clock calendar, comes before the court for a pretrial hearing on a theft charge. Parties have reached an agreement. She intends on entering a straight plea to the charge. There's a plea statement in O courts. City's going to recommend all suspended jail time, 364, all suspended for 12 months on the condition, no new criminal law violations, and a $250 court fee. She'd like to make payments.
Good morning, ma'am. Is your full name Deanna, middle initial Robinson Treptow? I'm looking at the statement of defendant on plea of guilty to one count of theft in the 3rd degree. Plea form tells me you're 34 years of age. Have you gone over the form with your attorney? And if you had any question at all about what it meant to enter a plea of guilty to a criminal offense, was your question answered? Now, if I accept the plea, this is to a gross misdemeanor. The maximum penalty would be 364 days in jail and or a $5,000 fine. I'd be free to impose that regardless of what's recommended, should I see fit to do so. You realize that. And if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. With that in mind, as to one count of theft in the 3rd degree, alleged to have occurred within the city of Yelm on July 10th, 2020, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I'm going to find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Heard the recommendation as to sentence. Mr. Hatfield, anything further to add? Mr. Haverco?
Nothing to add, Your Honor, would ask the court to follow it.
Ma'am, you have a right to tell me anything you wish regarding the matter. You don't have to say anything, but if you want me to know anything, now's the time.
Just for the court's information, she's got a much larger felony matter going on in Superior Court, and she might be looking at getting into drug court. So she's got other things going on, but it sounds like things are better. This case is older, and so I think she wanted to get this out of the way and off her calendar and move on to
Always
more
a good
bigger
idea.
things going on.
Now, I'm going to wish you the best of luck with that. Drug court is an excellent way to go in many, many situations. I'm going to follow the recommendation. 364 suspended, law-abiding behavior, $250 fine, payments $25 a month. That's not important to me. Any trouble making the payments, let Mr. Everco know we can deal with. Good luck to you. I want you to get a copy of today's paperwork at the window outside the courtroom to your left. Have that available for your attorney in the other matter and review it carefully. Good luck.
Couple more folks I got to talk to.
Back on record.
Do we need the city or?
I think the city can appear if it wants to, but and who would?
This would be, last name Paul, first
Stephen
name
Paul.
Stephen, three charges. It's on the 11 o'clock calendar. Matter comes before the court, on a controlled substance violation, loitering, drug-related activity, carrying a concealed pistol without a permit. And just for the record here, he's not actually prohibited from owning, purchasing a firearm. It's a situation where he had it unloaded in the trunk. It would be lawful, but he was inside the cab, so you have to have a permit in order to possess it there. So I mean, that's the issue. It's really a permit issue. So
That-
anyway,
Carrying a concealed weapon as it relates to vehicles has always been kind of a baffling.
yeah, well, it is lawful, if it's unloaded and in your trunk,
Yep.
you don't
it's
need a
okay.
permit. But if it's in the cab, it's
Gotta be on
considered
your
on your
body.
person, therefore you need, yeah.
So.
So-
Be that as it may.
Right.
Sorry.
So, yeah, so anyway, proposing a 6-month stipulated order of continuance on all three charges. Conditions, no new criminal law violations, $250 court fee. City would move to dismiss at the end of 6 months.
Mr. Paul, I'm looking at a SOC, stipulated order of continuance in the O court system. It's a contract between yourself and the city, negotiated by Mr. Aberco, your attorney. Under the terms of this contract, you can get these charges, all of them, dismissed if you comply with the conditions. Most important one, stay out of trouble. Far less of importance is the $250 fine. Make the payments if you would. Now, you've given up your right to go to trial to get this agreement for a dismissal. If there's a violation, city proves that, we'll have a hearing based on the police reports filed in the matter, and that'll result most certainly in a conviction for some fairly serious offenses. So I'm going to wish you the best of luck. You take care of yourself. Any question at all? We don't have any further need for it. If you're legally entitled to it, certainly can, and we can, that would be a question for-
I don't know if the court's going to put in.
That would work. Firearm no longer needed for evidentiary purposes. It's every once in a while I see in a situation where the police, they're not willing to part with the firearm because they contend there's a legal prohibition against it, and want to make sure that that doesn't happen. But yeah, if anything further is needed, it can come back before me. We can certainly put that in there. We don't need it anymore. Yes, and I would take, after I sign off electronically on the paperwork, you'll get a copy of it. And when you go to the PD, take your paperwork with you to show them that the firearm is no longer needed. Yes, you can get it just as soon as you leave the courtroom and go to the window but of course I have to sign it first and then electronically close it, and then it immediately goes over there. But I'm going to wish you the best of luck, Mr. Paul. You take care. Any questions? Take care of yourself.
We'll have to speak with Ms. Mills and Mr.
No problem. Back on record, Mr. Everco, I'll defer to you.
So, this is
Mr. Jones.
Mr. Jones. So he has several matters before the court, but in particular, there's two matters that we want to address first. And those are his two pretrial matters. One, that of criminal trespass first degree. The other case being that of criminal trespass second degree and a dangerous knives count. And I think the parties have reached an agreement. He is going to enter a straight plea on the case that started out, item number 7, the first degree, but it's going to be amended to that of criminal trespass in the second degree. And then upon the court's acceptance of that plea, the city will then move as part of the agreement to dismiss item number 8, the criminal trespass second and the dangerous knives count. And the city's recommendation is going to be 90 days in jail, all suspended. On the condition he have no new criminal law violations. Based on his evident status of indigency, the city is not going to request a probation fee, just that he try to remain law abiding and stay out of trouble.
Good afternoon, sir. Is your full name Kevin, middle initial J, Jones? Mr. Jones, good afternoon. I am looking at a statement of defendant on plea of guilty to 1 count of criminal trespass second degree, amended down from an original charge of criminal trespass first degree, case ending in number 2742. Plea form tells me you're 37 years of age. Any problem reading, understanding the plea form, going over it with Mr. Everco? That's it. Now, criminal trespass second degree is a gross misdemeanor, or a simple misdemeanor. The maximum, it'd be 90 days and or $1,000 fine, which I'd be free to impose regardless of what's recommended. Also, if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. Mr. Jones, with that in mind, as to 1 count of criminal trespass second degree alleged to have occurred within the city of Yelm on April 15th, 2024, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements. And as a result of the plea, the form also includes dismissals of criminal trespass second degree and possession of dangerous knives. Those will be dismissed. Mr. Radfield, anything further regarding sentencing? Mr. Everco?
Nothing to add, just ask the court to follow the recommendation and yeah, just hope that, Mr. Jones can, it's tough when you're trespassed from a lot of places and in a situation and so we just ask the court to follow that.
Mr. Jones, anything you'd like to tell me at all? No. I want to thank you for appearing. And, it's, try and stay out of trouble. I realize, yeah, that's, you're fairly limited in where you can go and what you can do, within the city of Yelm. But yeah, do the best you can, okay? And, as far as substances are concerned, save your own life, leave them alone. Yeah. I'm hoping. But any question at all? 90 days, all suspended on the condition you simply have law-abiding behavior. I'm not inclined to impose any fine at all. I don't see any point in that. There is, on the regard to docket numbers 3 and 4 and 5, city taking any action on those. Now, 90 plus 90 plus 90 plus 90 plus 90 adds up to quite a few months in custody. Mr. Jones, I want to remind you the keys to the jail are right there in your own pocket. You can stay out of jail by staying out of where you're not supposed to go and abiding by the law. Any questions at all? can get a copy of today's judgment and sentence by going to the window outside the courtroom to your left, look it over carefully and let Mr. Haverco know if you have any questions, okay?
Good luck.
Good luck to you, Mr. Jones. Take care of yourself.
Next matter will be Melinda Mills. Had a chance to meet with
Ms.
Ms.
Mills, good afternoon.
Mills and discuss this with the city. This is Melinda Mills, it's item number 15 on the 11 o'clock calendar. It comes before the court for a DUI charge. And I believe the city has a motion on this case.
Knowles, hearing no objection from your attorney as to the city's motion to dismiss. Case dismissed.
Okay, take care. I believe unless we got someone online,
No, that's, I think all we have to do is, process the, no-shows.
yeah.
Starting at 10 o'clock, let me leaf back to that.
On the 10 o'clock calendar, item number 1, Derek Berger. I did have a phone number for him and it appears to be a good number. I called the number, left a message to call me back, and I have not received a return call, so I don't have any information as to his whereabouts.
Haven't heard anything from him,
No.
so city have a motion. So ordered. Darren Carver.
I did have a conversation with him, and a while back, I wasn't sure how we were gonna handle the case, but I haven't received any subsequent message from here with regard to his non-appearance, so.
So ordered. Joe Frost,
And that's the one, the banging on the door. He's on the 10 o'clock. Joseph Frost, 10 o'clock, item number 3.
I'm not finding, hold on, I've got to do something. What was that? I'm not finding anything on her in the boards. Linda Mills, got it, there it is. You were right, the refreshing button needed to be pressed. Sigh. Hey, Joe Frost, that's drop it. Signed and closed. Stephanie Howanowski,
Haven't had any contact. I don't think last time I spoke with her, I don't think she had a working phone.
she was in custody, they released her on her promise to faint hope, which is better than no hope at all, that she would appear because she never does. So ordered. I was holding somebody already, didn't want to. think she might be in treatment.
Well, she called
I'm not sure.
apparently, and she was trying to make it to court. I was handed a note by the clerk, and she did call saying, hey, I'm having
Ah.
trouble getting a ride. Also, I know the city was going to anyway attempt to call the victim, and they haven't, the alleged victim, and they haven't, that hasn't happened yet. And so the parties are mutually asking the court to just note her non-appearance and to reset with notice.
Nothing on appearance for speedy,
Yeah.
trial purposes, reset with notice to be sent. How about Donna Klein?
So Donna Klein, she had given me a number, at court at arraignment, and I've tried to call the number. It's non-functioning. So I don't know whether she hasn't paid her cell phone bill or what's going on, but I haven't been able to even leave a message or anything. And, so I haven't had any contact with her at all.
So ordered, 1,000 cash or bond will issue. Kevin Jones.
And he was here.
resolved.
Yeah, he was here.
Dennis LeBlue, there's a. you've got
Yeah.
the-
I know. Yeah, I thought I, had something kind of worked out, but, yeah. Didn't receive any kind of call or, notice from, the defendant that they might not be at court or why they're not at court, so I don't have any information.
You have been in touch though. So
Yeah, did have a conversation, So, I'd ask the court note the non-appearance for speedy trial purposes and reset with notice.
Any problem? Any of that's, we'll do that. Note the non-appearance and reset with notice.
And then Emmanuel Mendoza, same situation. I, had a conversation with him and, we talked about potentially, getting an evaluation maybe of some kind to figure out maybe where to go in the case. And so I had anticipated him being here. That's why I had a motion to continue in Oak Courts, but, he didn't call me or leave me any information. I guess just like previous case, I guess I asked the court to note the non-appearance for speedy trial purposes, and reset with notice, but I realize it's a little more serious because it's a DUI
DUI
case.
is a little more concerning, especially if he was already suspended second, he's charged with that. I'm inclined to warrant. Yeah. Sorted. There's the infractions. Do you want those FTA? They're just, what's FTA those? Yeah. Melinda Mills, another DUI.
Yeah, and that was dismissed.
That's right.
That was dismissed.
I forgot to make the notation. Jason Tipton.
I wasn't able to, so I was provided a number, called the number, was not able to leave a voicemail because either it wasn't set up or one of these phone, cell phone issues.
I hate that.
So I know, but it seemed like it was a cell phone, so I did actually text him and said, hey, this is your lawyer in Yelm and your case is coming up and we need to discuss your case, so please call me, and left my number and never received any return, call or text or anything, so I haven't received any communication one way or the other, so I don't have any information as to his whereabouts.
Controlled substance, that's kind of a typical. So ordered, 1,000 cash or bond. Now on record for the 1 o'clock matters. I understand we have private counsel. They're both on Zoom. I'll explain that in a minute. We'll take those first. Yep. Good afternoon. I'm going to call Yelm versus Jason Jeremiah Clark. Mr. Clark in the courtroom. We have an attorney for, good afternoon.
Good afternoon, Your Honor. Allison Gannon, present on behalf of Mr. Clark. Mr. Clark and I have been in regular communication, and unfortunately, he had a pre-scheduled out-of-state business event he needed to attend today. So we are asking to set this arraignment over, Your Honor, to the next arraignment calendar.
Can certainly do that. Your Honor. August 15th work?
Yes, Your Honor, it does.
Do that. We'll simply send yourself and your client, Mr. Clark, a notice.
Thank you, Your Honor.
Again, thank you. You take care.
Bye.
And on the 15th. And we have one more in connection with.
Is Your Honor able to hear me?
I certainly can. Mr. Van Vega, can you hear me?
I can, Your Honor. I apologize. This is a new computer, so I just downloaded the Zoom for me today. I can't see myself on video here. Maybe if I
I'm going to call that right now.
oh, there we go. We have a this new computer has this little slide thing here so that you can see me. Apologize. I'm here for Ben McLeod, Your Honor. We're here for an arraignment.
Is Mr. McLeod in the courtroom? Mr. McLeod, if you would come up and have a seat at the council table. Your attorney's here on record. That's going to have a seat. Is your full name Benjamin Thomas McLeod? Mr. McLeod, the citation I have alleges that on or about July 16, 2024, you violated the terms and conditions of a order of protection. That would be a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. At this point, I'm going to turn to your attorney for the entry of a plea on your behalf.
Your Honor, at this point, we would stipulate to probable cause and say we are ready to enter a plea if not guilty. And Your Honor, I prepared in advance in courts an advisement of rights for my client, which I went over with him on the phone. I apologize, by the way, for not being there in person. It is not my practice to appear on Zoom, but I have 3 court hearings in Pierce Superior today at 1:30, and I didn't think I could make both. I have also filled out or had my client sign the basics of the conditions of release. Assuming that the city would probably want to add some additional stuff, but we are prepared at this point on those 2 forms as well.
Conditions of release ordinarily would just mean simply law-abiding behavior, maintain contact with your attorney, and appear for court as directed. Any objection to any of the next? We'll set the matter for a pretrial. Attorney pretrials are always at 9 o'clock. August 15th, 29th, September 12th.
One moment, Your Honor. Let me just check my calendar here. I'm inclined to say the 29th. At what time you said, Your Honor?
The 29th at 9 o'clock in the morning. Always on a Thursday, always at 9.
Your Honor, is it possible to get from the Yelm Courthouse to the Thurston County District Courthouse within 30 minutes, give or take?
No, 30 minutes. I'm in Olympia. That's yeah, you could do it in 30 minutes if you didn't get arrested for speeding in the meantime.
Okay, well, after the 29th, what would be the next?
And if there was no traffic at all, I would suggest going to September 12th.
So, unfortunately, I'm out of the country that day, Your Honor. How about the 19th? Would that work? September 19th?
How about the 26th? We don't have Thursday 19th, 26th.
I can do the 26th, Your Honor.
26th at 9. Mr. Radfield, you may have a better idea than I have about getting from here to Thurston County. Could you do it in 30 minutes?
I have a 10 o'clock in Thurston County is the only reason.
Not easily, not easily. Mr. McLeod, we're resetting your matter for a pretrial on the, the 29th of this month. That's, the 26th of September. Again, stay in contact with your attorney. Be back here on that date. Any questions at all? I'll sign an order to that effect. Mr. McLeod will be able to pick one up at the clerk's window before he leaves, and we'll be sending you a copy.
Thank you so much, Your Honor. I appreciate it. And I'll see you on the 26th.
Take care. We'll see you in September.
All right. And Mr. McLeod, I will be calling you after this hearing on the phone. Thank you.
Mr. McLeod, what I want you to do is go to the window, get a copy of today's order, and then be in touch with your attorney. Take care of yourself. Thank you for appearing. Everybody else is here for a first appearance. I always take private attorney matters first because they're always on the clock and don't want to run up anybody's bill any further than they have to. Each of you today will be represented and helped by our court-appointed counsel, Mr. Haverco, who's seated at the table. I'll call you up one at a time. You do have a right to have a lawyer represent you at all stages of the criminal proceeding, including today's hearing, the arraignment. Typically, at this hearing, a plea of not guilty is entered. Not any great statement about the case, but that's simply the way to preserve your rights pending a pretrial. Purpose of a pretrial is to determine whether or not the case can be resolved by agreement. Sometimes that cannot be done, in which case you're legally entitled to a public and speedy jury trial in this county. If you have any questions about what you're charged with or your rights, go ahead and ask myself or Mr. Haverco, and we'll make sure your question's answered. Is Cassandra Anderson in the courtroom? Ms. Anderson, step forward and have a seat if you would. Full name, Cassandra Marie Anderson. Ms. Anderson, the citation I have alleges in honor about July 7th, 2024. You committed the offense of theft in the third degree. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter a not guilty plea.
Plea of not guilty, as I indicated, does preserve your rights, Ms. Anderson. What I want you to do is give contact information to Mr. Haverco. His contact information will be on the order on today's hearing. Pretrial September 12th, 10 o'clock.
I need your signature. Need to sign it. Yeah, it is. I'll contact you.
Ms. Anderson, you take care. We'll see you back here at your pretrial. Exactly. Brian F.A. Ms. Anderson did leave without getting, again, when your hearing is over, I want to make sure you get a copy of today's order at the window. Don't run off without it. That just happened. Full name, Brian, middle initial D, F.A. Am I pronouncing your name right?
Yeah.
Right. Citation, I have alleged in honor about July 24th, 2024. You committed the offenses of loitering, drug-related activity, gross misdemeanor. The maximum penalty would be 364 days in jail and or a $5,000 fine. Also cited for use of drug paraphernalia, simple misdemeanor. Maximum penalty for that would be 90 days in jail and or a $1,000 fine. I'll appoint Mr. Haverco to represent you in this matter, and he'll enter a plea on your behalf at this time and represent you throughout the course of the case, should you be indigent.
Stipulate to probable cause, Your Honor, ask the court to enter a not guilty plea.
So they plea of not guilty preserves your rights. We'll set a pretrial.
Not yet. Yeah. And then I need. I'll be contacting you later. Yeah. Yep. So before you go to the first window, and I'll give you copies of the paperwork. Okay.
September 12th. 10 o'clock. Jeffrey Brown in the courtroom. Matter will come back to Robert Christian. Good afternoon, sir. Full name, Robert Allen Christian. Mr. Christian, I have one citation dated June 4th, 2024, alleging that on that day you committed the offense of obstructing a law enforcement officer in the performance of his duties. That is a gross misdemeanor. The maximum penalty on conviction for that would be 364 days in jail and or a $5,000 fine. You were then cited on July 4th for the offenses of disorderly conduct, resisting arrest, and obstruction of a law enforcement officer. I will appoint Mr. Haverko to represent you in these matters and will enter pleas on your behalf. The latter charges are misdemeanors with a maximum of 90 and or a $1,000 fine. Mr. Haverko?
Stipulate to probable cause on all matters and ask the court to enter not guilty, please.
Mr. Christian, any question at all? Your pretrial will be September 12th.
Before you go, again, Haverhill, you'll get my paperwork before you go to the clerk. She'll give you paperwork for your next court date. Mine. Yep.
Christian, thank you. Jason Clark does not respond. Mariah Anna Marie Clevenger does not respond. Number of people won't answer. At the end of the calendar, I'll go back through the files for the non-appearing person. If there was probable cause to issue the citation, a warrant will issue for their arrest. You've saved yourself a warrant just by showing up today. Mariah Clevenger does not answer. How about Amador Contreras? Good afternoon, sir. Full name Amador, middle initial D, Contreras.
Middle initial J, Your Honor.
I'll make that amendment. Mr. Contreras, the citation alleges on or about July 28, 2024, you committed the offense of driving while under the influence of intoxicants. It's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Mr. Haverko will enter a plea on your behalf at this time.
Stipulate to probable cause, ask the court to enter not guilty, plea.
Mr. Contreras, a plea of not guilty preserves your rights. We're going to set a pretrial September 12th, 11 o'clock. You'll get a copy of the order. It'll have the time and date on it. Please give Mr. Haverko your contact information.
Sign something. Yeah, so before you go with the clerk, pick up your paperwork, the court date, my info. Okay.
I will. Contreras, thank you. Kadisha Estes does not answer. How about William Eury? That's spelled E-U-R-Y. How about Candy Hand? Miss Hand, come on up and have a seat. the record, I have to affirm your full name is Candy Anna Hand. Ms. Hand, the citation alleges on or about July 3rd, 2024, committed the offense of theft in the third degree. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I will appoint Mr. Haverko to represent you throughout the course of this case.
Stipulate to probable cause, Your Honor, ask the court to enter a not guilty plea.
Ms. Hand, a plea of not guilty preserves your rights.
Just get the phone number. So when are you ready?
And that concludes the hearing. Any questions at all? Don't forget to get a copy of the order, and we'll see you back here at your pretrial. Take care. Thank you, sir. Marco Horton. Sir Horton, good morning. Or afternoon, as the case may be. Full name, Marco Joan, I'm probably going to mispronounce her name. John Horton. John Claude, I've never seen the spelling quite like that, but that's good. And a senior. Citation alleges on or about July 20th, he committed the offenses of knowing possession of a controlled substance and loitering drug-related activity, gross misdemeanors with a maximum of 180 and 1,000. Also cited for use of paraphernalia, that's a misdemeanor, maximum on conviction to be 90 and or 1,000. I'll have Mr. Haverko represent you in this matter, and he'll enter a plea on your behalf at this time.
Stipulate to probable cause on all three matters. Ask the court to enter not guilty, please.
Mr. Horton, the pretrial will be September 12th at 11 o'clock.
Yeah, write it down. This down, fine.
No problem, no problem.
So,
Mr. Horton,
you
the
need your
conditions
signature here.
release, of course, are law-abiding behavior. Stay in touch with Mr. Haverko and appear back here for court.
So just pick up your paperwork before you go, and I'll have your court dates and my info.
Thank you, Your Honor.
Mr. Horton, you take care of yourself. That's it. It'll be on the paperwork. Joshua Ottinger. Good afternoon to you, sir. Full name Joshua Frank Ottinger. Citation alleges in honor about July 16th, you committed the offense of driving a license suspended or revoked second degree. That is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverko to represent you. He'll enter a plea in your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter a not guilty plea.
So I want you to give Mr. Haverko your contact information. His contact information will be on the order.
Right. so you could- Good. Yeah, so before you go, see the clerk, she'll print out a copy of today's paperwork. It'll have your next court date and my contact information.
Thank you, sir. You take care. We'll see you back here in September. You as well. Charlie Jackson? Does not answer. Brett David Landred? Does not answer as well. Curtis Lopez? Not answer. Mr. McLeod, we did. How about Richard Metzinger? How about Jose Doroteo Ramirez? Ramirez Ruiz? I think we'll reset that matter. Nicole Schubert? How about Todd Snodgrass? Snodgrass, you were cited on July 16th for a driving license suspended or revoked, 3rd degree. The city may have a, what just happened is this. You walked in here, you were charged with a criminal offense, DWS 3rd. If you were convicted of that, that could bear up to 90 days in jail and up to $1,000 fine. City's amended the charge to a civil infraction. That means no possibility of any jail time. And if you admit the infraction, I'll assess a $150 fine. That'll close the matter. I'll take that as an admission and assess a $150 fine. Mr. Snodgrass, do you know what you need to do to reinstate your license? Yes. That's great. It's we live in a world where you pretty much have to be able to drive, but now the important thing here is get reinstated. If you can't make the payments on this fine, I'd rather have you spend your money on reinstatement. Let us know and we can work something out. But good luck to you. Get a copy of the order and have a good day. Take care. Tyler James Sorensen. Good afternoon, sir. For the record, I have to confirm Tyler James Sorensen is your full name. Citation alleges that on or about July 24th, 2024, you committed the offense of driving a license suspended or revoked 3rd degree, simple misdemeanor, the maximum of 90 days in jail and or a $1,000 fine. See, you're already set for a pretrial on August 29th at 10 in the morning. I think the city is not making a motion in this case. Mr. Haverco, I'll have you enter a plea on behalf of Mr. Snodgrass and, excuse me, Mr. Sorensen and.
Okay, yeah, because I think I'm already appointed on his other matter. Yeah, so would stipulate to probable cause and ask the court to enter a not guilty plea.
Mr. Sorensen, the plea of not guilty preserves your rights. However, let me warn you with this, Yelm, it's not that big of a city. Police pretty much get to know most of the people, especially the ones that are driving around without a license. There comes a point where
Write down your number. Oh, yeah, before you go, see the clerk, she'll make a copy of the paperwork. It's got your court date on it. You already have my contact info, but they'll give you another copy. It's a new case. Okay.
Sorensen, the conditions of release, once again, no driving without license and insurance. At some point, jail is kind of inevitable here. So that's very important. Do you not drive until you get your license reinstated? Very important, okay? Take care of yourself. That concludes the hearing. See you back here, your date of your pretrial. Take care. How about Jebediah Stecker? Jebediah Stecker does not answer. How about Ivani Villegas? Good afternoon, ma'am. Full name Ivani Rose Marie Villegas. Ivani, that's I apologize for mispronouncing the name. Citation alleges on or about July 19th, 2024, you committed the offenses of driving a license suspended, revoked, third degree, simple misdemeanor, maximum of 90 days in jail, and or a $1,000 fine. You're also cited on July 2nd for the offenses of negligent driving in the first degree, and driving a license suspended or revoked in the third degree. Same thing. Misdemeanors, simple, that's a maximum of 90 days and or $1,000. I'll have Mr. Haverko enter a plea on your behalf, and he'll do so at this time.
As to both matters, ask the court to, stipulate the probable cause. Ask the court to enter not guilty pleas as to both cases. Yeah,
So I guess conditions of release, the usual. Don't drive unless licensed and insured. And also, in your case, no drinking and driving. You have to get a copy of the hearings order at the window. Well, I guess thank you for appearing. Take care. Look, careful. Emmanuel Webster. And James Zilsdorf. I've run out of names to call. I still have people in the courtroom. Sir, you in the back? Pardon? Come on up and we'll deal with it. Now, what is your name? Oh, okay.
it's a DUI.
Yep, that's. Mr. Mendoza Ruiz, I called you earlier, but I may have mispronounced the name or right. That's for the record, your full name is Emmanuel, middle initial L, Mendoza Ruiz. Is that correct? Or is it Ruiz Mendoza? That's okay. Citation alleges that on or about June 9th, 2024, you committed the offenses of one, driving one under the influence of intoxicants. That's a gross misdemeanor. Maximum penalty on conviction to be 364 days in jail and or a $5,000 fine. You're also cited for driving license suspended, revoked in the third degree. Simple misdemeanor, 90 and or 1,000. You're also cited for driving license suspended, revoked second degree. And that's set for a pretrial at this time. I'm going to appoint Mr. Haverko to represent you on the new charge.
So I'm gonna fill out a speedy trial waiver, let's see, so that would be 84. And then 681. And it'll just take me a second, Judge. I'm gonna place so this, yeah, today's came on for pretrial and he's gonna, probably need a evaluation. So I've discussed this with him. So I'm gonna fill out I already have one in there. Okay, let's see.
Yeah, Mr. Mendoza, you were supposed to be here at 11 o'clock this morning.
We did, it's unfortunate he got confused on the time. We did talk prior to court though, and
You
had a
indicated
conversation,
that,
and
yes,
so we did communicate, and that's good. And he, I believe he's, we were wanting to, with the waiver in place, we've now just submitted a no courts, asked to reset it in the ordinary course that would allow enough time to get an evaluation, and where I'll probably need to provide copies of police reports and things of that nature. So I guess I'm thinking, if we could reset it to 6 weeks.
September 12th or
Sure.
26th?
Either one's good.
September 12th.
Okay.
Setting both cases for then. Excuse me, for some reason I thought this was arraignment, but it's actually a reset for a pretrial. Signing one of them. Relief, sir, but it's pretty important that we had ordered a warrant for your arrest, but that won't go out. But very important, stay in touch with Mr. Haverko and show up for court on time. That happens, but get a copy of the order at the window, and we'll see you back here in September. Take care.
See you later.
Good afternoon.
Oh, burger from 10 o'clock.
Yes. Derek Berger.
So I don't remember, I forgot to make a note on that one, so I don't remember if the court ordered a new notice or a warrant. I don't remember.
Warrant 1,500.
Okay, he is here. I'd ask the court to
Sure.
not issue the warrant. I think the FTA is still noted for purposes of speedy trial either way. And then would ask the matter be reset.
Reset?
Yeah.
We can certainly do that. City have any objection?
And I don't remember, do I still have it before you? We'll just do it again.
Berger, we need to reset your matter. It's a good thing you showed up before we left. Otherwise, there'd be a warrant out for your arrest.
So
Don't want to go there.
just so you know, I called you twice. You haven't called me back. Yeah, so called you on 6/14 and 7/26. I'm just saying, you haven't called me back. I always call from the same number. So you need to, or listen to your voicemail because I leave a voicemail.
Mr. Berger, there'll be a notice for you, at the clerk's window outside the courtroom to your left, but yeah, stay in touch with Mr. Haverco and make sure you're back here in time for court.
Okay.
It happens. Good luck. Man, is it hot in here?
It's hot. It's warm in here. It really is. It's really cold in the training room. Like the air con is really working just next door.
Next time, well,
Yeah, it's really,
and it's not good to go back and forth between
no,
hot, cold, hot, cold. That will give you a cold. Sure enough.
so yeah, he was trying to tell me that I didn't call him last time. Called him in June, called him just 3-4 days ago. Never returned.
Well, you were looking this way. He was asleep for. He was nodded out. He was on the nod. I don't know if they still have that expression,
Oh,
on the nod. That means you're.
maybe that's when he wakes up. This, yeah, well, from all that.
I started a little earlier than I should have, but now we're back on record. I'll call the 2:30 calendar at this time. Maybe you're the only one in the courtroom, so I'll ask you to identify yourself. Your name is? Tucker Allen Miskowski. It looks like you were given a speeding ticket, 19 over. Miskowski, you've asked for a mitigation hearing. That means you want me to reduce the amount of the ticket, which is $217. There's one other option you should be aware of. You're entitled to what they call defer, a one moving violation and one non-moving violation once every 7 years for each. A deferral, it's done differently in every court. The way I do it is this, if you want to defer it, we hold the ticket for a period of 4 months. If during the 4 months you do an online traffic safety school, that usually costs about $40. And costs I usually assess at, Donnie, 100, 150, somewhere in there. Which? Do you remember? Forget what I usually do. 150 instead of the 270 on the, so you're saving a little bit of money there and you're keeping it off your record. The reality is has a lot to do with insurance premiums. The better your record, so I'm going to give you that option. I would reduce the ticket from 217 to 150. If you want to save your deferral, keep it for future references, or I defer it under the what I just said, the 150 in cost plus the traffic safety school. Any question about anything I've just said? What would you like to do?
So just to make sure still.
Yep.
But that.
Yep. If you go 4 months without getting another citation, yes, it's then at the end of 4 months, if you've complied, filed proof of traffic safety school and paid the 150, ticket is dismissed. Doesn't go on your record. That is done online, and we can give you in the order that'll have. And there's a number of different. Always a good idea. Good idea. Remember that driving a car is probably the most dangerous thing you're ever going to do in your life. I've been in law, defense lawyer, prosecutor for about a half a century. Well, a half a century now, and I've seen just incredible amounts of carnage over the years. You have to slow down, relax, get there. There's a lot of anger out there on the road these days. It seems like a lot more since the pandemic. The best thing to do is relax and let the other people. You can't make the traffic go any faster than it is, and you're going to get there when you get there. And I'd rather have somebody get there safely than, like I've seen so many times, wind up in the hospital and really late about it. You want to do? That's what we'll do then. That's the better you can keep your record, the lower those insurance premiums, and insurance premiums are too high as it is right now. But you have the online traffic school information. I'm looking at the order that I'm going to sign here electronically. That is on there. So go ahead and do that and file proof within the next 4 months, and make sure the costs are paid within 4 months. And what we do is simply review the record, and everything's the way it should be. Dismiss the ticket, goes away. I've signed it. Mr. Miskowski, I'm going to wish you the best of luck. Drive safely, be well, and keep those insurance premiums as low as you possibly can. They're too high as it is anyway. But do you have any questions at all? At the window outside, same place you go to get a copy of today's order, outside the window or to the courtroom, and then that window down to your left. Sonia will give you a copy of the order, and Look it over carefully and let us know if you have any questions. Take care, happy motoring, and good luck. Take care. I will. Okay, let's do that. Let's do that now. Good afternoon.
Good afternoon, Your Honor.
We'll take, I understand you're on, appearing for, Kylie Victoria White,
Yes, that's correct.
set for a contested hearing with regard to a speeding ticket. I presume you have some preliminary motions that I'll hear now.
And thank you, Your Honor. I do. I did review the officer's affidavit and have a motion to suppress the radar reading. It was apparently used in the moving mode, but there doesn't appear to have been any indication that the speedometer was used as a cross-check, which would be a foundational requirement to admit that reading.
Yes, I'm reviewing the, officer's, statement at this time. Motion granted, I presume that'll be followed by a motion to dismiss.
Yes, it would be. Thank you, Your Honor.
Motion granted.
All right. Well, thank you.
Okay, that's, if you want, we can send you a order of dismissal. Sometimes clients like to have those.
It's not necessary, as long as it's reflected in the docket. That's good enough for us, Your Honor.
Be there. It'll be there.
All right. Thank you.
You take care. Have a good day.
All right, you too.
I will. Take care.
All right, bye.
Do that first. Back on record for the last of the 2:30s. I understand Ms. Langley is present by way of Zoom.
I am here, Your Honor. Thank you. I'm still in Thurston County as well, so appreciate the opportunity to appear by Zoom.
That's that comes across as pretty darn garbled. I could hear you, but I don't
How's
know.
that? Is that any better?
Wave, but go ahead. You're too close to the mic. I don't know.
I don't know. Let me try this. Who knows? It's my computer. It never works as well as my other devices. Anyway, I'm here on behalf of Taylor Linky. I don't know if he's here or not.
Nobody's here except.
But
Mr.
I did turn in this morning proof, at least, that he had insurance on the vehicle he was driving both times he was stopped.
Well, the insurance record I have was effective after the date of stop.
Well, I was hoping the fact that it also indicated that mom had been a continuing insured for at least 2 years would suffice, because that's what I got.
No, it has an effective date, 11/27/23, and
Right. Do you see where it says thank you for being I hope you have that. Thank you for being our customer for so many years.
back up from the microphone a little bit.
Oh, okay. Sorry.
Much
How's
clearer.
that? All right.
Go ahead.
So I was saying, I thought I looked at the dates and I said, well, this isn't what I need. But I think on there, it congratulates his mom for having been an ongoing customer. I'm hoping we can infer from that those vehicles were insured for more than just that one period. And I hope this will satisfy.
Oh, well, what do you want? What do you want me to do here?
Well, I think what we talked about last time, I know originally he was asking to have an opportunity to address these tickets. And I think you'd indicated to me that if we could at least get proof of the insurance, that there would just be a cost and that would be it. I don't know what we can do about anything else at this point.
Well, you have the insurance ticket. That is by far the most expensive one of the,
Yeah, and I think there's 2 of them.
and there are. Yeah, I'm looking at the one that says, date of violation 9/28/23, and the effective date of the insurance policy was 11/27. And there may have been, I don't know if this is a renewal. I don't have any information other than that.
Let me look at it. Guess I can't find my copy. I was quite sure that it said on there something about indicating that she was a renewing customer. I was hoping that was going to do it for us.
It's a pretty spare form.
Let me see.
Named insured Tiffany Mary.
Well,
And that.
it looks like he's trying to contact me now. I don't know what to tell him.
The trouble is here that also there's a named insured, and there's nothing on here that tells me if this is would cover
Yeah, I think the vehicle that he's driving is listed as an insured vehicle.
some of those insurance policies are just on the named insured. They don't cover other people. So I don't know about the policy.
Well, I don't know what else I can do. We've reset this a million times. Can we just leave the record open to see if I can drop off better proof of insurance and maybe it can be reduced then without further hearings? I don't know what else to do.
A couple of weeks or a couple of months or something.
Okay.
But the next court date is August 15th. We have one the 29th of August.
Well, I don't want to go out forever. Let's go out the 29th and I'll see if I can get something that actually shows that he's covered on those policies.
We'll reset her to the 29th.
Okay, thank you.
Taylor Linky, notice of any kind, Chris, or just you?
Yeah, well, why don't we send him notice? He's messaging me right now saying, oh, it was at 2:30. So I think he had the time wrong.
We'll take care of that.
Okay, thanks.
Yourself, good luck with your other hearings, and
Yeah.
and have a good day, and we'll revisit the case another
Again and again. Thank you, Your Honor.
Take care. Have a good one.
Back to Judge Wilcox. Thank you.
Well, out to the no-shows on the 1 o'clock calendar. The first one I have is Jeffrey Brown. That would be docket number 3, page 14 of today's docket. DWS is the charge, so FTA that once it's amended to no ball 2. The next one I have is Mariah Clevenger. Docket number 7, the next page, page 15. Probable cause was previously found when I dealt with this defendant in custody. 1,000 cash or bond warrant. In fact, most of the no-shows were dealt with in custody. Next one I have is Kadisha Estes, I presume. Again, amended no vol and FTA. Same way with William Urey. Amend to no vol and FTA. Ms. Hand did show up, and so the next no show I have is Charlie Jackson. Dealt with him in custody on July 24th. Assured me he'd be here on August 1st. Find probable cause for the offense of obstruction, 1,000 cash or bond. The next one is Brett Landred. Amend DUS to no vol and FTA that one as well. Next one, Curtis Lopez, cited with a couple of infractions, operating without headlights and improper lane usage. FTA those. I also find probable cause for the issuance of him of a DUI. It's a first, but the breathalyzer was 3.3 and 3.5. And he was walking normally and talking normally, and the driving pattern wasn't all that bad. It sort of indicates he may have been in a fugue of alcohol-induced amnesia. In other words, he may have been just completely blacked out. With 3.3, we don't see those every day. 5,000 cash or bond. After Mr. Lopez, we go to Richard Metzinger, who was going to, did appear early, but disappeared on his disorderly conduct charge. He was released from custody on July 18th, found probable cause then for disorderly conduct, 1,000 cash bond. Nicole Schubert. Well, first of all, the next docket number 21, no file for that, but that one's reset. That was one of the, it should be, yeah. But that brings us to Nicole Schubert. The probable cause was previously found when I talked to her in custody on theft 3rd, 1,000 cash or bond. Jebediah Stecker. Probable cause for DDoS 3rd, 1,000 cash or bond. A couple with just those multiple. The next would be Emmanuel Webster. Go ahead and reset. There's a note in the file. Reset the arraignment with notice. And then last would be James Zilsdorf. Amend to no vol 2 and FTA. And that is